Delivering this week's must-watch workplace storylines, this is Bloomberg Law's Punching In, for those of you listening in Washington and across the globe.
Hi, folks. Thanks for punching in with us. Our first item today is about some personnel movement in the labor space. My colleague Paige will be joining me. Hey, Paige, how are you?
Hi, well, how are you?
I should have said your last name, Paige. It's Paige Smith, and I'm doing well. We'll jump right in. So tell us, I believe the agency is OFCCP. Who exactly is being moved from there, and what are their responsibilities?
Absolutely. So there's been a lot of leadership changes within the agency. The most recent is a woman named Deborah Carr, who's sort of the agency's policy guru. So, you know, anything that is really directly affecting big federal contractors like Amazon and Google and Raytheon is, you know, sort of at the, or I should say was sort of at the mercy of Deborah Carr. Deborah Carr's last day will be on Friday, and her landing place is unknown right now.
Gotcha. And sort of by way of background and the significance of her position, I know you reported last week that OFCCP released for the first time a list of federal contractors that it was going to be auditing. Can you say just a bit about that?
Absolutely. So this is the first time in history that the agency has actually compiled and published a list of the names of companies that are going to be audited. And that's significant because not only does it give contractors a further heads up that they're on this list, but it also lets folks like you and me know that, you know, these are companies that are under the microscope for, you know, things like anti-bias laws and anti-discrimination,
that kind of thing. Right. And so do we know yet where she's headed and who's going to be filling her position now?
We don't know. We reached out to the agency for comment and it was declined for now, but we'll just have to wait and see.
Right. Is there are we expecting a bit of a shift here? Are we expecting someone who might lean more to the right or to the left than she is? Someone that might be a copycat essentially, or what exactly?
We're unsure as of now, but we do know that the agency is focused, it's sort of full steam ahead with this transparency initiative. But how that will be carried out in future policymaking is yet to be seen.
Great. Thanks for joining me, Paige.
Thanks so much for having me.
Our next item today is about business compliance, which generally also implicates workers' rights. And this is about the apparently varying advice that lawyers and law firms, I'm sure that also includes in-house counsel, are giving different companies as to how they should comply with a joint employer rule. That's fundamentally about the question of who's your boss, right? And that generally sounds odd, but my go-to example here is if you imagine a guy who works for a cleaning contractor that has a contract with a McDonald's store. They go in at the end of every day and sort of clean up the entire facility. And so on the employer side, there's a question of, let's say that guy suffers a slip and fall. Let's say that guy is owed overtime one night and isn't paid it. The question is, who's liable? Who's on the hook for that, right? Is it the contracting company? Is it the guy who owns the McDonald's? Is it maybe even McDonald's corporate, right? And on the worker's side, there's a question of who does he go to get a remedy? And of course, this is a big deal nowadays because there's so many businesses that are set up in this sort of fissured way. So the current rule that's in place from the Obama era makes it easier to hold both the guy who owns the cleaning company and the McDonald's location, maybe even corporate as well. And that's going to be tweaked very soon. We could see policy there coming out of there's a DC court that's looking at the Obama era case. The Labor Board is engaged in a rulemaking, and the DOL more recently announced they're also engaged in a rulemaking. So that, of course, leaves businesses in a bit of a weird, uncertain space. And apparently some attorneys have been advising clients to comply with the rule that's currently in place. Others say you can sort of exert more control over the contractors, et cetera, and so on, because the NLRB isn't going to be pursuing cases under the standard. Now, the reason for that is, of course, because the NLRB is under Republican control. There's a bunch of Trump appointees in there right now, and the administration itself, as well as those appointees, disagree with the approach that the Obama era put in place, which would make it easier to hold multiple businesses liable in the situation I described before. So we'll be keeping an eye on that and follow up in the column, of course, where my colleague Chris Opfer would have a bit more about how these lawyers and businesses are dealing with this issue. For our last item today, the Labor Department is holding its last listening session today in Providence, Rhode Island, over the overtime salary threshold. That's basically a cap or a ceiling, and if folks earn less than that standard, they're automatically entitled for overtime pay, time and a half. The current threshold is $23,500. That's a Bush standard that went back into place after an Obama change was struck down by a Texas court. So the DOL will be listening to folks about sort of how it should tweak that rule, and more than likely will raise the threshold. That's a bit of a ways away, but we'll of course be trying to get the scoop on that and let you know as early as we can what the new cap might be. All right, that's it for this week, folks. Thanks for punching in with us for the Labor Desk's Monday Morning Musings. For more coverage, be sure to check out our website where the Punching In column is hosted. That's news.bloomberglaw.com. And of course, you can always follow me on Twitter at Hassan Kanu. See you next week.